Laura, I want to go to you on this one, please. You're certainly no stranger to high-profile trials. Some of you, our viewers, might recognize you from being part of Scott Peterson's defense team. And with this case, we've got these two big looming issues, the $27 million settlement announcement and then the announcement that was leaked of the plea bargain that was in the works, where Derek Chauvin was essentially set to plead guilty to third-degree murder, serve 10 years in prison at least, but that was blocked by Bill Barr. Tell me your thoughts on the public knowing about these issues as and before the voir dire process has begun.
Obviously very damning. I mean, yes, the judge can say this was a political decision. Yeah, probably it was. But how do you convince the jurors of that? How do you, the jurors, no matter what, are going to think, any potential juror or a juror that's been picked is going to think, wait a minute, if there was plea bargaining, and now there's a $27 million settlement. Ooh, it's not just one thing. There's two things here that possibly show that there's probably some guilt here. I mean, we've got, the city feeling that there was a huge risk, or they believe that there's guilt, whether it be in their procedures and the way he was trained, or based on Chauvin's actions. And we've got Chauvin, on the other hand, also considering a plea bargain. For the lay person, I mean, lawyers will understand it. Lawyers will understand, okay, it doesn't necessarily mean that there's guilt. People sometimes don't want to take the chance. They don't want to risk 45 years to life or whatever the sentence may be for the worst case scenario. But the lay person may not understand that, and the lay person is going to take it as face value. And that is that there's guilt here. Not only does Chauvin possibly think he's guilty, but that also the city or the government feels very strongly that he's guilty. We've got also the case that's been filed. So I think it's very damning, regardless of what the original reasons for it are.
Right.
And we've seen that in the Scott Peterson case. I mean, we saw after the media focused on the case, everybody was just glued to their TVs during that trial. And people went in with their own, having made up their minds, and nothing at the trial changed that.
Lara
They went
Yeretsian.
in without the presumption of innocence.
Laura, give me your take on prospective juror number 71, if you would, please.
I agree with Julia that saying that I'll do everything I can is just not going to cut it. Saying I'm going to try and overcome my formed opinion is not going to work. I mean, the defense, the one question I'd want to ask him is, would you pick yourself as a juror if you were sitting or if you were in Chauvin's shoes? And my guess is his answer is going to be no. I mean, this man has made up his mind. He used the word seared as an answer in the questionnaire. If that image of that motionless officer and George Floyd on the ground is seared in his memory, and he keeps on repeating that he can't get that image out of his mind, how can anyone keep him on the jury? And you can see the judge has pretty much made up his mind. I know the prosecution did a pretty good job in trying to rehabilitate him and got him to say a couple of yeses as far as following the law and the elements. But I mean, it's pretty clear this juror has got to go for cause.
I'm with you, Laura. Let me bring in our special legal analyst guest. We still have with us criminal defense attorney Lara Yeretsian. And Laura, we were chatting earlier about high-profile cases, some of the difficulties, and I was saying to viewers how you're no stranger to such cases. You were on Scott Peterson's defense team, and when we went to break before, you said there were those challenges, right? And you felt like there were some media challenges that occurred in that case. And talk to me a little more about that and what you see as issues in this case because of some of these things being so widely known, like the plea bargaining that was taking place and also this civil settlement that's now been announced.
Well, typically in the high-profile cases, clearly there's a lot of media attention, so there's a lot of information out there. And the jurors come into the case having at times made up their minds because they hear all sorts of facts. And they are influenced sometimes by some of the opinions that they hear in the media coverage. And, they could be influenced by that. And they come in, like I said, having made up their minds. And that's really tough on the defense. The more high profile, the more tension, the more pressure also on the jurors. And overcoming that is extremely difficult, especially where you've got jurors who have an agenda. They have an agenda. They want to get on that jury. They've already made up their minds, and they either want to convict or acquit. It could be either, correct? So it could be either one. But they will give the right answers, and they know exactly how to answer the questions. They will say unequivocally they can be impartial jurors and follow the law, and they understand the concept of presumption of innocence, but in the back of their minds, they've already made up their minds, and they will say anything to get on that jury. The one thing that we saw with the previous juror, he seemed very genuine. At least he wasn't lying. He was trying his best to say, I'm going to try my best to be fair. Yes, I can be fair. But at the same time, he was qualifying a lot of his answers. But at least he was honest. And the judge could see through all of that, even through his yeses, that, this man is just not 100% sure. The cause, he has to be dismissed for cause. But we had situations in the Peterson case where people were hiding information, crucial information, that had, for example, the defense known, they would have been able to get that juror dismissed or kicked off the jury for cause, or maybe use their peremptory challenges. And that's one of the main issues, one of the real issues, troubling issues with high-profile cases, really being able to see those stealth jurors who have an agenda and are trying to get on the jury.
Excellent points, Laura. Something I've seen throughout this process, watching both sides, is that I wish they would ask more open-ended questions of these prospective jurors and just let the jurors do more talking. And I know it's, as somebody who's sitting watching from the outside, it's much easier to say that than it is to actually do it when you're there. There's a lot of pressure on both sides. The state, is feeling enormous pressure, to get a conviction with Derek Chauvin. And the defense is feeling enormous pressure to defend him and uphold the rights that he's afforded by our Constitution. And as I'm watching this, that's something jumping out at me. Did that jump out at you at all today as you've been following along? Do you feel like these attorneys need to let the prospective jurors speak a little more?
Usually, if the juror is someone that you like and is given all the greatest answers, and for example, you're the defense attorney, you love this particular juror, you're not going to want to ask any more questions because you don't want any information that to come out that the prosecution is going to use for cause, right?